Is your prenup ironclad? Challenging and enforcing agreements in NY. New Yorkers often sign prenuptial agreements to protect assets and set expectations, but these contracts are only as strong as the law allows. Small errors can lead to invalidation, and courts apply some of the strictest rules in the country. Anyone facing a divorce or planning a marriage should know that a prenup must be carefully drafted and executed to survive judicial scrutiny. The controlling statute, Domestic Relations Law Section 236, b. 3, imposes 3 non-negotiable conditions. A prenup must be in writing, signed by both parties and acknowledged in a form sufficient to record a deed. Verbal agreements and bare signatures have no weight. Each signer must appear before a notary, orally confirm their voluntary execution and obtain a certificate stating the notary had satisfactory evidence of their identity. Courts treat acknowledgment errors as fatal. In Matisoff v. Doby and Galetta v. Galetta, agreements were voided because the acknowledgment was missing or omitted a critical phrase. Proper acknowledgment differs from mere notarization and requires strict adherence to form. Because of these rules, the answer to whether your prenup is ironclad depends on both form and substance. Once an agreement satisfies the statutory requirements, it carries a presumption of validity, but the opposing spouse may still challenge it on grounds of fraud, duress, or unconscionability. Fraud requires intentional concealment of significant assets or liabilities, not minor omissions. Duress demands proof of threats or pressure so severe that the signer had no reasonable alternative. Feelings of anxiety or a threat to cancel the wedding are not enough. Courts look to factors such as timing, independent counsel, and financial dependency, but only a convergence of elements will support a claim of coercion. Unconscionability focuses on fairness. A prenup will be struck down only if its terms are so one-sided that no sensible person would accept them. Successful challenges typically show a pattern of overreaching, such as withheld disclosures and grossly disproportionate terms. Maintenance waivers are subject to careful examination. Courts take a second look at the time of divorce and will reject a waiver that leaves one spouse unable to support themselves. A 2025 case, JM v. GV, held that a waiver is only knowing if the prenup includes the presumptive maintenance calculations, including both parties' incomes and the guideline amount. A simple statement waiving maintenance is no longer sufficient, particularly when one party is unrepresented. Attorneys drafting prenups must include these calculations to preserve enforceability. To enforce your agreement, your attorney must present it in court and show that it is facially valid. Once the basic requirements are proven, the burden shifts to the challenger to provide specific evidence of unfairness. Challengers sometimes attempt to flip the burden by claiming that the relationship between engaged couples creates a presumption of undue advantage, but the best defense is to show a fair and transparent process. Evidence that both parties had independent legal representation, exchanged complete financial disclosures, and had time to review the agreement will support enforcement. Courts give significant weight to signed and acknowledged financial schedules and to proof of ongoing negotiation. A prenuptial agreement is more than a contract, it reflects trust and planning. New York's strict technical and fairness standards mean you need a knowledgeable lawyer to draft and defend an agreement. Whether you are creating a new prenup or seeking to enforce one, working with a Manhattan divorce attorney who understands these rules can help protect your interests. For guidance, contact the law office of Richard Roman Shum, Esq. This law firm is located at 20 Clinton Street, Frant 5D, New York, New York, 10002, and the phone number is 646-259-3416. This trusted law firm serves clients throughout Manhattan and offers confidential consultations. A competent attorney can help ensure your prenuptial agreement truly safeguards your future.